My dad's house was in a living trust, and in order to refinance the house, a lender told him he needed to take the house out of the trust and put it back in his name. He did that. It was his intent to put the property back in the trust right away. However, things happened. He became ill. He passed away before putting the house back in the trust. As the successor trustee, do I need to file a regular probate petition? Hello again. This is Daryl Williams, a real estate broker with Win-Win Realtors here in Southern California. Thanks for watching. On this program, we assist executors, administrators, and successor trustees with real property that's going through the probate process. One of the issues that occur when a trustee refinances their property, most of the time they are required by the lender to remove the property from the trust in order to refinance the property. The trustee does that and in some cases forgets to put the property back in the trust. Things happened. The trustee passes away, and now the property is no longer in the trust. How is that problem resolved? If the intent were to put the property back into the living trust, you as the successor trustee can petition the probate court to have the real property placed back in the living trust. Chances are the probate court will allow you to put the property back in the living trust and proceed with the settlement of the estate based on the instructions of the living trust. Some trustors, people that own property, are concerned about the due on sale clause in their loan documents. A due on sale clause is the lender requires that the loan is paid in full if the trustor, the borrower, sells the property without their permission, if the borrower transfers the property without their knowledge and or permission. They'll require that loan to be paid off in full. However, in this case, you need not worry about that because there are laws that prohibit the lender from calling the loan if you transfer the property into a trust or certain other entities. One of the main reasons that the lenders want you to remove your property from the trust prior to refinancing is they want you to remain on the hook for that loan. They want your name to be on those loan documents, thus to make sure that you remain responsible for that loan obligation. Thus, if you have a living trust and you have taken your property out of the living trust in order to refinance your property, be sure to put that property back into the trust. You will save your family members from a bunch of stress. You'll save your family members a lot of time and a lot of headaches. If you are a successor trustee, a person that's named in the trust to handle the administration of the trust after the death of your loved one, if you are a successor trustee and the property was not placed back into the trust after a refinance, know that you can, here in the state of California, petition the court to have the property placed back into the trust and then proceed with the settlement of the estate based on the instructions of the trust. All right. I'm Daryl Williams. This is Win-Win Realtors TV, where we help executors, administrators, and successor trustees with real property that's in the probate process. If this video has been of value to you, please subscribe. This video has been for information purposes only. It is not intended to be legal advice. I am not a real estate attorney. If you need legal advice, please consult an estate planning attorney or a qualified attorney. If you don't know a qualified real estate or estate planning attorney, please feel free to contact me, and I'll be more than glad to give you some referrals. Thank you so much, and I'll see you next time.